That's kind of how I'm viewing it. He's pro se, so it's the filing that the court received doesn't. It asks for relief the court can't grant in this case because the only issue before the court is should he be allowed to deregister.
Yes.
But I'm viewing it as a sort of renewed petition or an amended petition that just sort of adds more information and bases for the request. But before I even get to really any of that, Mr. Fredrickson, have you ever provided to the court the conviction record for exactly the crime in Illinois with which you were convicted?
I believe that is in Exhibit X. There's supporting exhibits and requests by the court, including psychological evaluation.
I got a lot of information, but I have not seen
the actual docket and the notes from the docket is in there concerning the ending of my probation and the decision by the court to release me from the obligation to complete
right.
those.
I'm looking for the statute under which you were convicted. That's what I'm having a hard time locating. Can you point me to that?
And Your Honor, if I could approach with what has a couple things been marked as Exhibit X, but I do believe that the statute is noted in this document that Mr. Fredrickson provided.
Why don't we take a gander at that?
And then I have a motion. Did you say yes, or?
I'm sorry, Mr. President. I need some time to think. I'm not totally sure of what you're asking for, and so I think we need to talk about it.
But if you could approach with
okay,
that
I can
Exhibit
look
X,
through
that would be
So
appreciated.
this is what approach you go, Mr. Fredrickson. Show.
Oh, yeah, that's not a problem. Anything that I gave you, I mean, that's...
All right.
Something to note that I found out is a little bit unusual is Illinois is a one-crime, one-charge state. So there was actually 3 counts, but I don't know under which of the 3 counts they found it. So,
All right. So, but you pled to one of these.
yes, sir.
So, count 1, aggravated criminal sexual abuse. The defendant knowingly committed an act of sexual penetration on JW, who was at least 13 but under 17, in that the defendant placed his penis in the vagina of JW, and the defendant was at least 5 years older than JW. Okay. Then the next page shows count 1 again. Kind of an interesting. So then count 2.
It was confusing at the time, too, Your Honor, because, again, it's a one-count state, so I don't know how that's talliated.
Well, then count 2 says defendant knowingly committed an act of sexual penetration with JW, who is at least 13 but under 17, and that the defendant placed his mouth 5 years older. Okay. And then count 3. Defendant knowingly committed an act of sexual penetration who was 13, at least 13, but under 17. So the way I read that statute is the victim here was at least 13, but no older than 16. And the defendant placed his finger, and the defendant was at least 5 years older. All right. And you were convicted of one of those, is that correct?
Yes, Your Honor, I believe that's correct. Again, one act, one crime state.
And then this says you that were convicted. So the probation order says convicted of the offense of aggravated criminal sexual abuse, of which all 3 of these counts are actually named that in violation of, and then it's really hard to read, 7-2 something.
It'd be 720, I believe, or 702.
Chapter 20,
I could have
720,
told you about memory.
Section 512, 16, subsection D, of which all of these are sectioned. Class 2 felony. So that would be consistent with the charges that were there. And then the court would note this Exhibit X was in the file, and I reviewed it, but it's in a longer document.
I apologize, Your Honor.
It's okay.
The only thing I submitted was things that were supported 3 times. I have a plethora of things that are supported twice, so I was trying to keep it reduced.
All right, so on February 24th of 2003, the minute order from the court says, matter comes on for plea. Court finds the defendant's plea is knowing and voluntary to the offense of aggravated criminal sexual. Now, the reason I just went through that whole process, Ms. Kunish, is because if you go to Title 16, 1622, 113, that is the statute that goes through petitions for removal from sex offender registry. Subsection 3, which is the very end of the statute, says the following persons are not eligible for relief pursuant to this section, but are subject to the remainder of their natural lives to the registration requirements specified in Article 22, or to the comparable requirements of any other jurisdiction in which they may reside. And subsection B, Roman numeral 1 and 2 states, any person who is convicted as an adult of sexual assault in violation of 183402, and you can stop there, and then sexual assault on a child in violation of 183405. Those 2 statutes, so 183402, sexual assault, subsection 1D and E, any actor who knowingly inflicts sexual intrusion or sexual penetration on the victim commits sexual assault if, at the time of the commission of the act, the victim is less than 15, and the actor is at least 4 years older than the victim and is not the spouse of the victim, or at the time of the commission of the act, the victim is at least 15 years of age, but less than 17 years of age, and the actor is at least 10 years older than the victim and is not the spouse of the victim. Given that, do you believe Mr. Fredrickson is even eligible to deregister?
I do not, Your Honor. And I would just say, I think what is marked for me as Exhibit 3D seems to be information from the Illinois Sex Offender Information website. It's a little bit hard to read what the actual website is, but it does look like it's a .il.us thing that says the victim was 16 years of age and the offender was 38. So I believe that is the closest thing to information I have about the actual the Illinois statute versus the Colorado statute, where I think we do fall into that over 15, but more than a 10-year age difference.
Because our 2 statutes would overlap
Yes.
that other statute.
Yes.
Now, it is a 5-year age difference as opposed to a 10-year age difference.
Under their statute, but I think that if it was charged in our jurisdiction based on the ages that are represented in this information, it would have been the 10. It would have. And I guess I didn't look if there is a 10-year age difference in Illinois or if they.
I'm going to get the issue. Mr. Fredrickson is